Welcome, everyone. Thank you for joining us for the first session of our two-part webinar series, Understanding the EPA's new regulatory revisions to water quality standards for protecting tribal reserved rights. My name is Vishwatej Attili, and I serve as an environmental analyst at the National Congress of American Indians, NCAI. It is my privilege to host this series organized by the NCAI's Institute for Environmental Sovereignty with the generous support of our co-sponsors, the National Tribal Water Council, the National Association of Wetland Managers, and the American Bar Association section of Environment, Energy, and Resources. Before we begin, I want to thank our co-sponsors and partners for their invaluable contributions and commitment to this critical work. This collaboration underscores the importance of shared efforts to uphold tribal sovereignty, protect vital water resources, and enhance environmental justice. Before we proceed, I am pleased to introduce our moderator for today's session, Ken Norton. Ken is an enrolled member of Hoopa Valley Tribe and serves as a director at the Hoopa Valley Tribal Environmental Protection Agency. With over 40 years of experience in environmental protection, Ken is a seasoned expert in water quality and the development of water quality standards. From 2004 to 2009, Ken had the honor of serving as vice chair of the National Tribal Operations Committee, where he was a lead spokesperson for tribes on national tribal EPA water issues. Today, Ken chairs the National Tribal Water Council, where he continues to advocate for the health and sustainability of clean and safe water for Indian communities, Alaska Native tribes, and Alaska Native villages. We are thrilled to have Ken moderating today's session, and I know his insights and leadership will add immense value to our discussion. Before we begin, a quick reminder. Please use the Q&A feature to submit any questions during the session. We will address as many as possible during the Q&A at the end. The recording of today's presentation and the presenter's slides will be available on the Institute of Environmental Sovereignty's website once they are processed and uploaded. Thank you again for being here. Let's begin today's session and engage in a productive conversation. Ken, over to you.
Thank you. Hello, everyone, and welcome to today's webinar on the nuts and bolts of EPA's Tribal Reserved Rights Rule for Water Quality Standards with a collaboration story with tribes and states. As mentioned earlier, this is the first of two sessions hosted by the National Congress of American Indians, Institute for Environmental Sovereignty, and partnership with the National Tribal Water Council, the American Bar Association, section of Environmental, Energy, and Resources, and the National Association of Wetland Managers. The purpose of today's webinar is to present the rule and explain how EPA and states will consider applicable tribal reserved rights when developing water quality standards, with an emphasis on increasing transparency and clarity where the reserved rights apply. The second session, held on January 30th, 2025, will explore the state implementation of the rule, including challenges and opportunities. We will hear from state representatives and from the Native American Rights Fund about legal issues and areas of opportunity that benefit all parties. Again, I'm Ken Norton, chairman of the National Tribal Water Council, and will be moderating today's webinar. Thank you for joining us. Now I'll just give a brief overview of the rule. On June 3rd, 2024, the Water Quality Standards regulatory revisions to protect tribal reserved rights became law and effective for state waters where they apply. Prior to the ruling, it was up to the state's discretion to recognize and establish water quality standards that are protective of tribal reserved rights. In many cases, this process was overlooked, placing many tribal members who are dependent upon aquatic and aquatic dependent resources at risk. EPA recognized this concern and issued a rule that applies to treaty, legislative, and executive order based rights that allow access to aquatic and aquatic dependent resources protected by the Clean Water Act. And if they do, and the right holders assert them, the regulations take effect and the rights are considered a part of the state's standard setting process under Clean Water Act 303C. In this webinar, we will learn what the rule entails and what comes next, specifically how changes to federal water quality standard regulations at 40 CFR Part 131 define tribal reserved rights for the purposes of that rule. We will look at what EPA's responsibilities are for states in regards to tribal reserved rights in the water quality standards context, and what are EPA's responsibilities to the right holders and its oversight role. And finally, we will hear from a tribe who has responded to the implementation of this rule with a particular emphasis on preserving aquatic and aquatic dependent resources, which are essential to the tribe's traditional way of life. Well, we were informed earlier today that due to a directive from the current administration at EPA's Office of Water, that our representatives will not be joining us, unfortunately. But fortunately, we have a fill-in. Donna Downing, with a senior analyst with the National Association of Wetland Managers, will be filling in, and with myself doing our best to present the rule and what it entails. We will have Nancy Schultz, Water Quality Project Coordinator with the Fond du Lac Band of Lake Superior Chippewa Indians, sharing the Fond du Lac experience of coordination and cooperation amongst a tribal nation and a state in implementation of the rule in protecting tribal resources without resorting to legal actions. At the end of our presentation, we have set aside time for questions and answers. So let's get started, Donna, and we'll do our best and to present the rule. Thank you.
There. Am I audible? Can you hear me?
Yes, Donna.
All right. If someone else could run the slides, that would be great. And may I have the slide number 2, which is the first slide with content, beginning with background, which is always a good place to start. That looks right. If you put it in, yes, perfect. All the way up. Okay. Thanks, everybody, for the unexpected opportunity to talk with you about the Tribal Reserve Rights Rule. I currently am the Senior Legal Policy Advisor for the National Association of Wetlands Managers prior to that, I was in EPA's Office of Water for 20-something years. I am not the expert that we had lined up for you today from EPA. I am no longer with EPA. Again, I have to emphasize that. But what I'm going to do is work through this slide deck that we have. And with Ken and perhaps Nancy and maybe Charlie's assistance, we'll lay down the basis of what the tribal reserved rights rule provides so that it helps put the stories that others will be telling both during this webinar and the webinar a week from today in context. So context. The next slide, please. Thank you. Context really matters, and I think it matters a lot here in the tribal reserve rights as well. Many tribes have rights to natural and cultural resources that are reserved either expressly or implicitly through treaties, statutes, or executive orders. And historically, environmental regulatory schemes have not always recognized or protected those rights. And this places tribal members who rely on those vital resources for sustenance and to support longstanding cultural practices at disproportionate risk. And the stated objective of EPA's rule that, as Ken pointed out, became effective last June, is to establish a framework for how those tribal reserved rights, as defined in the rule, must be considered when establishing water quality standards. So the goal is to protect those reserved rights because they are important, they exist, they're very important for protecting the health and sort of cultural and physical health of tribal members. The rule does define, next slide please, tribal reserved rights that are protected under this rule. And it defines them as any rights to Clean Water Act protected aquatic and/or aquatic dependent resources reserved by rights holders through federal treaties, statutes, or executive orders. Now, EPA, in its preamble to the rule, hastens to say that they are not purporting to establish or interpret rights that may exist or the scope of those rights. Rather, this definition provides that those rights that are reserved by treaty, statute, executive order, that fall within the gambit of resources that are protected under the Clean Water Act are within the scope of this rule. And whether a tribal reserved right, as defined in this rule, will result in a new or revised water quality standard is a case-by-case inquiry with the provisions. But as Ken emphasized, it's no longer an optional provision. By the way, one of the important background contexts, I think, is that tribal reserved rights exist, obviously, on tribal lands, but they also can exist and be pursued on non-tribal lands. And that's why this rule is so important, because it puts states in a position that they need to take into account those reserved rights that exist off of the reservation for which the state is developing water quality standards. Those standards off the reservation elsewhere in the state need to protect those asserted tribal reserved rights. And some states, as we'll be hearing in this two-part series, have protected tribal reserved rights or sought to prior to the finalization of this rule. Other states are finding themselves in a new territory. Next slide, please. Let's see. All right. I have 3 screens going and I have 3 versions of the PowerPoint all on different pages. So we'll see. So what does this require of the states? First, the rule does require that if a tribe asserts a tribal reserved right in writing to a state and the EPA for consideration and establishment of water quality standards, the state must, to the extent they have available data and information, take into consideration the use and value of its waters for protecting the tribal reserve rights. And they also need to take into account the anticipated future exercise of the tribal reserved right, unsuppressed by water quality, in establishing the relevant water quality standard. And then it also, the state, needs to establish water quality criteria to protect the tribal reserved right. An example of the issue of suppression, suppressed uses of the right, and the need for criteria adapted to reflect the use of that right is, for example, in fish consumption, where historically some criteria used to develop water quality standards assumed sort of the state average consumption of fish. And in many instances, tribes and individual tribal members consume a much higher rate of fish. Two things might happen. One is they might not be as protective of their health because the assumptions underneath the standard don't apply as directly to the tribal member. Or the other might be that the water quality is such that there aren't as many fish to eat. That's also thought of as a suppressed tribal right. This rule tries to address both of those kinds of questions, that the water quality is sufficient to protect and exercise the tribal reserved right, and that the protection of tribal members reflects the actual consumption of the resources and is as protective as it is for the community as a whole. And Ken, if there's anything you want to add at any time, please chime in.
Okay, thank you, Donna.
All right.
Next.
Yep. And let's see. Again, a variety of states have sought to protect tribal reserved rights in the past prior to this rule. That gives us access to sort of best practices and lessons learned and cautionary tales. But now all states are required to take into account, when developing water quality standards, protection of these reserved tribal rights. Let's see. The other aspects that the rule does, it does commit EPA to providing technical assistance, both to states and also to tribal rights holders as in evaluating the reserved rights, and also initiating a tribal consultation process. The rule lists a variety of factors that EPA will consider when determining whether state-adopted new or revised water quality standards are consistent with this new rule. In other words, appropriately protecting asserted tribal reserved rights. And then finally, the rule modifies the procedures for state review and revision of water quality standards to include any new information available regarding tribal reserved rights. As I think many of you know, there is a statutory requirement for reviewing and updating as necessary water quality standards every 3 years, known as the triennial review. And reserved tribal rights are, under this rule, becoming part of that update and one of those considerations. Next slide. So what opportunities does this provide for tribes? One is tribes can assert their reserved rights for consideration in this water quality standards context. It also provides an opportunity for tribes to sort of describe and document the geographic scope and nature of their rights. Where are they in the state beyond those that are on the reservation? Information about desired revisions to relevant water quality standards. What other information do you have and perspectives would you like the state and EPA to have before them and to discuss with you as they work on water quality standards development? It's a real opportunity for an ongoing conversation. And also it encourages and provides an opportunity for tribes to consult with EPA to inform their review of whether water quality standards that the states have adopted are appropriately considering asserted tribal reserved rights. Some tribes have sought to assert prior to the finalization of this rule. This rule provides a format and a commitment to listening and encouraging that conversation. Next slide. Okay, here's a sort of a summary slide. As you know, EPA proposed this rule and received a large number of public comments suggesting what might be tweaked and what should be retained. And in response to those comments, EPA has flagged 3 changes that they made in response to what they heard from tribes, states, the general public, and others who submitted comments. One is that when a tribe asserts the reserved rights, that triggers the rules requirements. So that allows tribes to decide whether and when to raise their rights for consideration in the water quality standards context. You are not compelled to do so. It is left up to the individual tribes to decide when and where, tailoring it to their own needs and concerns. It also seeks to limit the burden on states by not requiring the states to conduct independent inquiries about where are and what are those applicable tribal reserved rights. Many states were concerned they'd have to become experts on treaties. EPA in its preamble says that's not the case. Another issue was, I mentioned suppression effects, where, for example, the water quality might be such that there isn't enough fish to fulfill the tribal reserved rights in a particular water. And it indicates the states have to, quote unquote, take into consideration those possible suppression effects, and requires that their resulting water quality standards reflect consideration of unsuppressed exercise of tribal rights. How much fish would you eat per capita if they were there, for example? When data and methods exist, there isn't a requirement to develop whole new databases and methodologies for this, but it's using what we have and hopefully pushing that to be a little bit better. And by this approach, EPA hopes that it will provide flexibility in what I think we all acknowledge is a fairly complex and evolving area. EPA is planning on engaging early in the process if the parties, states and tribes, request and it's feasible. And this helps minimize and facilitate resolution of any disputes that might rise. So EPA, as I said, took comments on the proposal and revised it to reflect these three issues that were pretty dominant in the comments received. Next slide. Always for more information. These is the link for EPA's website to this rulemaking, which will provide you both with the rule, the economic analysis, the press releases, sort of fact sheets and the like. And it also includes an example implementation scenario, drawn from many, many experiences. It's not a specific one. That illustrate a hypothetical tribe's assertion of its reserved rights in the water quality standards context, how the states consider those rights, and how it might result in a revision to its water quality standards to protect those rights, and EPA's subsequent water quality standards review when the state submits, as it does for all water quality standards, the standards for EPA review and approval. So there's a lot of good information there on their website that you can consult. Next slide. Well, how about that? Thanks for letting me bend your ear. I heard that I was bending your ear about 15 minutes before the webinar began. But that is the world we live in now, and we will keep moving forward. And I think during the discussion here in this webinar, we'll have a lot of shared information, and that's the goal of it. So thanks, everybody, and I'll turn it back to NCAI. Hello. Ken, over to you.
Yeah,
All righty. Well, thank you, Donna. And I'd just like to re-emphasize that the rule memorializes tribal reserved rights in federal law. The water quality, the revisions to Part 40 CFR Part 31 are federal laws. And so where prior to that, as you pointed out, Donna, and I pointed out, it was state discretion. So as we move forward, one other comment that I'd like to make is during the initial rulemaking, there was a lot of language that said the state must do these activities. They must abide by these type of rule regulations. That language changed till shall consider. So that would I like to point those out. Comments from where that the rule was weakened. We'll see how that plays out. So I'll turn it back, and hopefully we have Nancy on board with a presentation on the interaction between the tribal nation, Fond du Lac, and the state, I believe, of Wisconsin.
Thank you, Kenny. And thank you, Donna, for stepping in
Yes.
on such a rushed timetable. I had no doubt that you would be able to manage this beautifully, and you did. Okay. Everybody able to see my screen?
Yes.
Yes.
Awesome. All right. Well, I'm really happy to have been invited to give a presentation today around this new rule that just went into effect last June. It's something that, as a member of the Tribal Water Council, along with Ken Norton and others who are on the call today, this is a rulemaking that we closely tracked and engaged with EPA headquarters on. But in my presentation today, I'm going to talk a little bit about our water quality standards because that's some of the context that that our experience brings to the table. And I'm also going to talk about actually implementation of this rule that's going on not just in Wisconsin, but also now in the state of Minnesota. And so I'll be able to give you some examples on both sides of the state line. So this map is intended to kind of bring home the importance of off-reservation reserved rights in this particular part of the country. In the Great Lakes region, ceded territories are a profound part of our work on and off the reservation for tribal nations. There were many treaties that were signed between the U.S. government and various tribal nations bands in the 1800s primarily. These are just some of them that weigh prominently in the comments that I'm going to make today. If you look at the yellow 1837 polygon in this map and the green 1854 polygon in this map, those are primarily what I'm going to be talking about today. The purple 1842 is also relevant because these are some of the treaties that created not only reservations, reserved lands, but lands that were ceded to the federal government where the signatory tribes retained in perpetuity the right to hunt, fish, and gather. And to zoom in even a little more closely in the state of Minnesota, you can see there's the Fond du Lac reserved lands in the 1854 ceded territory, just inland from Lake Superior, but there are numerous other treaty areas, and they are in various stages of adjudication, conflict, acknowledgement, etc. But for the tribal nations who signed those treaties and who are managing resources on and off the reservation, they really ring significant to all of us in the work that we do for our tribes in this particular region. I know that in other parts of the country, the political framework and the status of how different tribes are able to exercise these off-reservation rights can be really different. But the story here in the Upper Great Lakes really revolves around some very basic subsistence and cultural resources. Manoomin, Scene, or wild rice is one of those resources, and it really dominates a lot of the work that we do for our tribal nations up in this region. It figures prominently in the history and the migration of the Ojibwe people over centuries through the Great Lakes Basin, where they were guided by prophecies that led them to the place where food grows up out of the water, wild rice. And it's a being, a relative that is of utmost subsistence and cultural significance to the people who rely upon it as a subsistence food source. And it's also ecologically really important. The landscapes and waterscapes that we have up here are really represented by the kinds of ecosystems that support monomen and other important aquatic related resources that tribes up here rely upon. So I'm going to be talking a lot about wild rice, and I'm going to be talking a lot about fish, because obviously consumption of fish is another really fundamental subsistence life way of the tribes up in this region. And it's not something that is just historic or aspirational. These are practices that are ongoing today that, again, really drive the work that we do in our environmental programs and our natural resources program on behalf of our tribal governments and our tribal communities. Props to the Great Lakes Indian Fish and Wildlife Commission, one of the really effective and active intertribal organizations up in this region. Also have some really good mapping skills, but this gives you a sense of the geographic, spatial extent of wild rice waters in the modern day. Wild rice used to be found in much more of the United States waterways, pretty much in all of the states east of the Rocky Mountains. Back at the turn of the last century, there were documented occurrences of wild rice. But now it's pretty much confined to the upper Great Lakes. And you can also see the coincidence of those wild rice waters with reservation lands and off-reservation or ceded territories. And up here in this area, the tribal nations are the ones that are really driving the emphasis on protection and restoration of this cultural and natural resource. To that extent, some of the work that I've done as a biologist and an ecologist for the Fond du Lac Band, I've also had to stretch out into other avenues of investigation and communication to be able to adequately describe the significance of monomen to the Ojibwe people and other indigenous peoples of this region. We've done things like economic analysis and ecosystem services analysis. We did a health impact assessment where we were able to bring tribal voices into a document that helped us really communicate and articulate the significance of this aquatic related resource and why we would go to such lengths to try to advocate for its protection and restoration. It isn't just a subsistence food source, a nutritional source, an ecological linchpin. It's also really fundamental to the cultural, spiritual, and mental health of the tribal communities who have relied upon it for many, many generations. It's at the heart of the passing of traditional knowledge and of language and of seasonal activities. And to Donna's comments earlier about the assertion of when and how a tribe might decide to assert these off-reservation rights. This isn't something that has just come about in the last 6 months with the tribes up in this region. We've been really vocal and really active and engaged with state and federal agencies around just broadly the protection and the restoration through all means possible, including federal statutory protections like that under the Clean Water Act. Strong advocates for the using all available tools and processes to protect this fundamentally important resource. I list some examples of some of the things that tribes up in this region have been doing for decades now in our engagement with state and federal agencies, not only to assert and document these tribal reserved rights, but also to engage and to bring useful and actionable information to those agencies so that when rules are being promulgated, when decisions are being made, when permits are being drafted, that the consideration of how that would impact important off-reservation resources like monomen or fish has been taken into account. We didn't wait for this rule. We've been doing this for a long time up in this region. As one of the 50 or so tribes nationwide with federally approved water quality standards, we've known here at Fond du Lac for a long time how important it is for us to have data, to have the science to back up the arguments that we make, the comments that we make, the recommendations, and the advocacy that we do. And we know that when water quality standards are proposed to be added or revised or updated, any changes to existing water quality standards or new proposed standards must be grounded in science, and they must be approved by EPA. So we're familiar with the utility of our monitoring programs and our collaborative research opportunities. To that end, we have long engaged with other tribal agencies, state agencies, academic institutions to advance the Western science, and not only bringing the traditional knowledge to the table, but to actually be on the forefront of pushing the knowledge around what it takes in terms of environmental quality to protect and sustain these important resources. And we've helped to advance the science around what kind of water quality and quantity, for that matter, is necessary to preserve sustainable wild rice in this region. When we did our last triennial review, not only did we rely upon the science and the health impact assessment, but we also promulgated a narrative standard to protect the habitat and the hydrology, because we understood that those were important too. Again, these are the same kinds of recommendations and comments that we make on a consistent basis to our state and federal partners. The other large time suck, if you will, in working for a tribe that is trying to protect its aquatic dependent resources that are also subsistence resources, is contamination in the fish. This is another, we're not like the salmon tribes of the Pacific Northwest, but walleye, northerns, and other Great Lakes fish are an incredibly important part of the diet and in relation with the Ojibwe people of the Great Lakes. And so we're in an area where mercury contamination is a really profound problem. It's been really intractable, and we don't seem to be making as good progress as other regions are. And then, of course, there's a whole slew of new chemicals of concern that we need to be really vigilant about. And so we're not just thinking about that from a purely research basis, but also how does that impact tribal on and off reservation fishing, being able to exercise those treaty rights in off reservation seasonal fishing. Our tribal members do eat more fish than the general population. And some of that is aspirational because, quite frankly, a lot of our water bodies up here have been impacted by mercury, for instance, or by some of the industrial legacy contamination that has been left behind in the Great Lakes region. More recently, our tribe has begun exercising those off-reservation treaty rights on Lake Superior and accessing another incredibly important fishery resource. And then finally, I'll mention just one last potential water quality standard interface that has been important to our tribe. In our most recent triennial review, we also proposed a specific conductance criterion, and it was primarily to protect aquatic life. We had been trying for more than 25 years to reestablish a population of lake sturgeon in the river that forms one of the boundaries of our reservation. They used to be really prolific here, then abundant, but they've been overfished. Their habitat has been degraded, pollution has impacted them, and so as we try to reestablish them, we also have to protect the necessary water quality for them. And again, we relied upon science that EPA had initiated and guidance. We relied upon our own data and data that was accessible from the state to promulgate a standard, which EPA reviewed and approved. So now I'm going to pivot to how are we trying to actually live out and implement this new reserved rights rule up in this upper Great Lakes region in the states of Minnesota and Wisconsin. I'll start with the state of Wisconsin. If you recall, the rule was published in May of 2024 and finalized in early June of 2024. Later in June or right around the same time, the state of Wisconsin published their triennial standards review work plan, which is kind of the kickoff or the initiation of their triennial water quality standards review process. It's where they reach out to the public and ask for input. They ask for data and interest in what the public thinks should be important and pursued in this round of water quality standards review. And so at this time, Fond du Lac and one of the intertribal organizations that I mentioned earlier, GLFWC, Great Lakes Indian Fish and Wildlife Commission, they implement off-reservation treaty resource management, monitoring, protection, policy, etc., for 11 of the tribes that span from over in Minnesota, including Fond du Lac, and through the state of Wisconsin, and I believe also in the state of Michigan, kind of across that swath that I showed in my first map in the Lake Superior Basin primarily. And so at that time, we submitted comments to the Wisconsin DNR, which is the state agency responsible for implementing Clean Water Act in the state of Wisconsin, and had comments on how we would like to see them consider protection of off-reservation treaty resources, such as wild rice, with the water quality standards that can protect them, with consideration of a higher rate of fish consumption that is much more reflective of a subsistence rate, because what they have in their state water quality standards right now does not reflect subsistence fishing. And so there was a letter that was signed by the tribal leaders of all of the member tribes under this Voight Task Force framework that essentially asserted the treaty reserved rights to harvest aquatic and aquatic dependent resources in the territories ceded to the United States in the treaties of 1837 and 1842. It also spoke to the history of those treaty rights and their litigation and how they have been affirmed all the way up into federal courts. And I'll zoom in a little bit on some of the language that was also included in that communication, which was shared not only with the state of Wisconsin, but also with the regional administrator in EPA Region 5, where we're located. And I call attention to the highlighted statement here that the lifeways that we're trying to protect here, the traditional tribal lifeways depend on the unsuppressed use of these beings for spiritual, cultural, medicinal, subsistence, and economic purposes now and for future generations. And I think any of you who are on the webinar today that work for tribes can understand and relate to that language. That's how we approach our roles and responsibilities in working for tribal nations. It's about the relationship with those beings, those resources, the fact that it is interwoven not only in just what do we find to eat, but just the entirety of lifeways, spiritual, cultural, and even to some extent economic purposes, but finally now and for future generations that focus on we're not just talking about today, but we're talking about into the future and caring for those that are to come. And it's essentially pointing out that the Wisconsin water quality standards as they are today certainly are not protective enough of those priorities that were expressed by the tribes. So since then, mind you, this is all just unfolding in the last several months. To date, in the state of Wisconsin, there has been a preliminary meeting between the tribes and the tribal agency I mentioned earlier, GLFWC, the Wisconsin DNR and EPA, both the regional office with the water quality standards and tribal programs and Office of Water at the regional office, and also at EPA headquarters. Those that were active on the rulemaking who were unable to participate today, unfortunately, were really interested to see how this essentially first test case of implementing the new reserved rights rule, how it was playing out. You're going to hear in the webinar next week about how it's not going very well. There's been hostility and backlash in other parts of the country with other states who aren't really interested in this kind of coordination with tribes. However, my purpose today is to show how it can work and how it can follow what was laid out in the reserved rights rule. And it can just be an opportunity to strengthen tribal and state relations and elevate protections for these shared resources. So there will continue to be coordination between the Voight Task Force, that's the kind of the governing body of this intertribal agency. And as was pointed out earlier, the kind of the focus right now is prioritizing a change to the fish consumption rate so that it's more reflective of a subsistence of fish consumption, and then to examine establishing a wild rice beneficial use or designated use in Wisconsin's water quality standards, and to take advantage of the science that has been done to demonstrate the protectiveness of a particular numeric sulfate criterion. And so we've got a lot to bring to the table. It isn't just, we wish you would do this. It's, we believe that it's important to do this, and here are the reasons why, and here's the data to support it. And I just learned from my colleagues over at Glyphwick that just yesterday they received a communication back from the Wisconsin DNR, and they have actually revised their triennial standards review work plan, the document that was shared back last summer, to include or elevate those priorities that were identified in the tribal assertion and the tribal input to their triennial review process. So it looks like it's working. At least we're following what the procedures are that are laid out in this rule. And I guess I will remain hopeful that we will see some outcomes in this particular triennial review period for the state of Wisconsin that may not have otherwise happened but for this rule. Meanwhile, in the state of Minnesota, there's also just recently a triennial standards review document, a work plan that was shared with the public at the end of the year back in December, but actually shared with the Minnesota tribes several weeks earlier. We've actually established a working relationship with the state agencies, in particular the Minnesota Pollution Control Agency, under our state government leadership from the governor on down through all the state agencies. There's been a lot of progress made in terms of establishing collaborations, coordination, consultation when it is appropriate, and essentially finding a way to work together and share knowledge. And to that end, the tribal staff are generally given a courtesy early look at any proposed policy changes, rulemaking, etc., environmental decisions, those sorts of things. We have a chance to see it before the general public does. And again, that's a major change in perspective. It essentially acknowledges that the state agencies recognize that in working with the Minnesota tribes, they're not just working with the general public or another stakeholder or an environmental group, that they are working with sovereign nations. So not only was there that early notification, but there has been outreach from the Minnesota Pollution Control Agency to tribal environmental staff to look at how they may be able to incorporate traditional ecological knowledge in this particular triennial review process. It feels a little vague to me right now. I don't know exactly how that's going to be accomplished, but the conversations are getting started, and I think that's a good thing. And so right now we've got a deadline coming up in a couple of weeks where the state is looking for input from the general public, but also from Minnesota tribes into what we think would be important for them to focus on. The state has a work plan. They have their priorities established and kind of tiered according to right now, maybe in a couple of years or maybe in a few more years. Right now, the comments that I'm working on would essentially ask that they elevate or reprioritize some of the, for instance, aquatic life use criteria that would be important to protect important treaty resources, like the lake sturgeon that I mentioned, to continue to enforce and implement the water quality standards that are on the books already for the protection of Monoman, to work hard to try to improve and reduce the amount of mercury contamination, for instance, that are in the fish populations that we rely upon. And then I would just leave you with one last, maybe rather unique situation in the state of Minnesota. I'm not sure whether any of my colleagues from the Red Lake Nation are participating today, but they've had an unusual situation whereby working for their tribal environmental program and with the Minnesota Pollution Control Agency, they have been working collaboratively on establishing site-specific, essentially site-specific eutrophication standards for Upper and Lower Red Lake, where there is shared jurisdiction between the state and the tribe. And so that is in process right now. It's been through a comment period. The technical support document is in revision and review right now. It will be submitted to EPA Region 5 in the very near future for approval. Would expect to see this particular site-specific water quality standards package finalized this calendar year. So that's kind of what I have to share about how we see this rule being implemented up in this region. And I think that we have good opportunities. Hope we continue to establish and strengthen coordination and collaboration between the tribes and the state agencies, and that we see progress being made in terms of state standards that apply to waters that we do not have the jurisdiction to establish standards for, and rely upon the state to establish them and implement them and enforce them so that they are protective of our off-reservation reserved rights. Miigwech.
Thank you, Nancy, for sharing the current experience with the Fond du Lac Band in its interaction with states. It's good to hear that progress is moving forward, but we all know that this progress just didn't happen overnight. There were many ups and downs in achieving the tribe's assertion of their rights. Now, I believe we have time, and I want to say a half hour for questions and answers for our panelists and myself. So if I may, if we don't get to all of the questions, we currently there are, I'm looking at the screen, 21 questions. We may provide a written response and then have that listed or presented on the NCAI webpage.org. So that's something that we can discuss with our host presenter. So if I may start, we have a question from Cohen. Could you expand on the directive that restricted our panelists, EPA panelists, from participating today? And I may just quickly answer that. Cohen, we just got a notification over our emails that it was an internal directive at EPA that all external presentations will be restricted to a later time. We know that there are going to be a selection of a new or we do have a new administrator, and then a selection of the AAs within those EPA programs. So this is all we know, is that unfortunately, as of this morning, we just got the directive, the notification from our EPA counterparts. Moving on from Gary, does the ongoing dispute over the definition of waters of the United States influence the rule? And I turn that over to Donna.
Thanks, I think. When I was at EPA, I was jurisdiction team leader and led the staff efforts to define waters of the U.S. and worked with DOJ to defend the resulting definitions that we've had. So in terms of, does the ongoing dispute over the definition of waters of the U.S. influence the new rule? Yes and no. Doesn't that sound lawyerly? The rule, the Tribal Reserved Rights Rule, is being done under EPA's authority under the Clean Water Act, Section 303, that sets up this collaborative federalism between states and the feds and tribes, should they choose to get treatment in a manner similar to a state authority for water quality standards. Those standards, though, are under the statute only required to come and addressing waters of the United States. So the extent and the new rule on reserved tribal rights is enhancing that 303 Clean Water Act, Section 303 process of developing standards for waters of the U.S. The Supreme Court decision in May of 2023, the Sackett case, shrunk the scope of waters of the U.S. considerably. The agencies, states, tribes, and the general public, and NOM and everyone else are still trying to figure out exactly how much and what it means. But if something isn't a water of the United States, their standards are not compelled under the Clean Water Act to be developed. That said, states and tribes can always choose to develop standards consistent with this rule under state or tribal law. So yes or no? Does the debate over what waters of the U.S. should be directly affect this rule? It does not change any of the definitions of tribal reserved rights. It doesn't change any of the processes, etc. But it does affect the scope of waters that standards developed and intended to be submitted to EPA for Clean Water Act review, because there are fewer of those waters in the U.S. Kind of a roundabout response, but hopefully that helps.
Thank you. Thank you, Donna. We have a next question from Jake, and I will focus this one to Nancy. Is water quantity, minimum flows, a water quality standard of these tribal reserved rights? I think you touched upon that, Nancy, in the narrative criteria that's being considered.
Yeah, that's right. And that's what I would expand upon. I know that when people think about water quality standards, they're usually thinking about chemical concentrations in milligrams per liter, or contaminant levels and human health risk levels. But narrative standards can also encompass some of those other environmental indicators or environmental quality parameters, such as hydrology or habitat, minimum flows that are important seasonally for spawning. There's any number of ways that you can incorporate water quantity type protective ranges in a narrative fashion through a water quality standards ordinance. And I would absolutely advocate for tribes pursuing that as a priority for engaging on revisions to water quality standards, because I think that anybody who's trained in Western science or hydrology or ecology understands that those physical conditions and features are every bit as important to protecting those beneficial uses that are at the heart of your water quality standards. I hope that helps.
Thank you, Nancy. Our next question is from Andrew, and he asks if a body of water and what is within that body of water is a traditional dependent resource, such as fish, rice, shellfish, and such, why do the states and feds always want to push recreation? And I leave that up to both panelists to take a crack at that.
Want me to start, Nancy? Okay. It's always fun to say, oh, the statute made me do it. The Clean Water Act was enacted in its current form in 1972, and happily the world has shifted and expanded the types of concerns that we want environmental statutes to address. In the Clean Water Act, it talks about, among other things, the goal of the act is to restore recreation on and in the water, make water fishable, swimmable, and so forth. So over the years, picking up on that, particularly EPA and similarly often the states have figured, well, all right, recreation, and have tended to pick up on that statutory language in implementing regulations and in some of their styles. But the awareness of the breadth of concerns about, for example, cultural uses and all have more recently become a concern. And I'm going to throw part of this question back to Ken as well, because EPA had proposed what's called a baseline standards for for use on reservation lands that would have explicitly made, I believe, traditional ecological knowledge and cultural values co-equal with achieving sort of recreation and I'm trying to remember what the third one is, but unfortunately, the last administration felt it couldn't finish that rule and they withdrew it earlier this year. But the interest and the knowledge and science and evaluation that was involved in that rule remains. So I think that hopefully, and with reserved tribal rights, we'll see a continuing shift away from sort of focus on recreation and that kind of thing. So that tees it up to you, Nancy. But the statute made us do it, kind of.
I don't think I have much to add, Donna. You know the Clean Water Act inside out, and you know how EPA has approached implementation over the years, as well as anybody. I would just call everyone's attention to the obvious that all water bodies have more than one beneficial or designated use. And it's hard to know exactly what the situation or scenario is that this person has with regards to, why do they think that recreation is being held up as a priority use. It could be that they don't have a lot of data to support assessment of other beneficial uses. I'm always reminded about how important all the different pieces of the Clean Water Act are, not just water quality standards, because you set standards, but then you also have to monitor and assess to see if they're achieving those standards, which theoretically are protective of the uses that you want to protect. You need to set limits and permitted discharges. You need to list impaired waters and then go about restoring them. I mean, there's all different ways that you implement standards, including that swimmable or recreational beneficial use. And it could be that for whatever reason, they don't have sufficient quality or quantity of data to assess for other uses. But that's just one guess.
Yep. Great responses. I just want to add that when Donna teed up on the baseline water quality standards and EPA's withdrawal, I know there's a great interest out there in Indian country on what is next. In our coast NCAI, is interest to. This may be a future discussion, a future webinar. And I see our our NCAI host with his hand up. If you may chime in quickly, we greatly appreciate it.
Hi, I wanted to mention about Daniel Cordalis from NARF, Jennifer from Oregon Department of Environmental Quality, and Dana from the Minnesota Pollution Control Board are also on the panel, just so that you can use their expertise also in answering
Okay.
some of these questions. Yeah, thank you.
Okay, I didn't know that. Thank you. Our next question is from Gary Moshishima. And Gary, forgive me for maybe mispronouncing your last name, but I recognize you, Gary, as a long-time tribal environmental advocate. So Gary asks, the rule does not require adjudication of tribal water rights, correct? And I believe, no, it doesn't. But I'll let Donna or Daniel chime in on this with their lawyer background.
Ken, my lawyer background agrees with you, but I'm going to defer to Daniel since I think he's a little more active on that specific question. But that wasn't a big issue that states raised during public comments and EPA attempted to address so that they would be less concerned about the need to decide what was a reserved tribal right or not. They didn't feel they had the expertise. And I think that the adjudication question in the final rule reflects their concern. Daniel?
Yeah, thanks, Donna. You're right on that. I mean, there's, I think the better defined a tribal treaty right is, the better it will work for this process. The off-reservation reserved right, and states are very wary, and something we'll talk about next week in the litigation is having to, quote, adjudicate tribal treaties. They don't want to be in that position. They don't think it's their job. I think as tribal advocates, we probably don't want it to be the job of the United States either. And so while no doesn't have to be necessarily already adjudicated, in most of these instances, they already are. Tribes who are fighting for these resources typically know whether their fishing rights are solidified and have been before courts before, and it can provide evidence and clarifying background for that. And there's a little bit of discretion too for the states when these questions are not clear. There's wiggle room for them baked into the regulation for them to almost kind of put their hands up and say, we don't have enough information to go forward on this, therefore we're not going to address this. So while it's not required that they are, the more information there is that helps a tribe assert and define what their rights are, the more easily those rights will be, and those water uses will be able to be incorporated into revised or the new standard.
Thank you, Daniel. Next, we have Naomi asking, does the rule facilitate challenging oil and gas development that will impact water resources and their water quality? It's kind of an open question. I'll leave that. Anyone from the panel would like to, if they take a crack at that one.
I'll raise my hand to start, because when you start, you can say some of the easier stuff, and then and Nancy and other participants can fill around with the tricky stuff. When a water has a water quality standard under the Clean Water Act, that water quality standard is used to guide a lot of different permitting decisions. Often, development of oil and gas requires permits, for example, for discharge of dredged or fill material under Section 404, or perhaps a permit under Section 402 under the NPDES program. All of those have to be consistent with applicable water quality standards. The degree to which future water quality standards explicitly protect reserved tribal rights, then those reserved tribal rights have to be in the middle of those decisions. Similarly, there's a section of the Clean Water Act, Section 401, Water Quality Certification, that has a variety of considerations, but under 401, no federal agency, including those, for example, who might be permitting or issuing permits and licenses for oil and gas development, have to get essentially a certification from the state or tribal area where the discharge would originate, that it's consistent with a lot of different things, including applicable water quality standards. And those can be both those approved under the Clean Water Act, as well as other water quality related considerations on tribal lands. So does the rule facilitate challenging? Yes, to the degree to which it provides an explicit sort of water quality standard for waters, and it will require then consideration of the oil and gas development on the quality of those waters, and a decision as to whether or not it's consistent with the proposed project. So with that, I'll turn it over to anybody else.
I think you did an excellent job, Donna, talking about the other Clean Water Act rules. And
water quality standards are the skeleton of most of the programs under the Clean Water Act, because the water quality standards are the specific articulation of the overarching goal of the act to restore and maintain the chemical, physical, and biological integrity of the nation's waters. And so once you have those more specific articulations, the programs under the Clean Water Act have to seek to help bring those about to actually happen down there, out in the real world and in the river streams and wetlands.
All right, we have another question from Naomi, and this might be going into our second session, and it'll be asked of Daniel. Is there any concern that the current administration will renege on the rule or refuse to uphold it? And Daniel, I know that this probably be a discussion on the second session, but I'll let you respond as further as you wish to.
Short answer is yes. I think the withdrawing the rule takes a little bit of work. You can't simply write it on a piece of paper. You have to go through another rule-making to actually withdraw the rule, because the rule is beyond the Congressional Review Act timeline. So while it won't necessarily be too hard to undo it, it also won't happen before the webinar next week. So, but there will be, of course, there's lots of things that, and all regulations seem to be going to be under extreme scrutiny. We've got a challenge by 12 states, others who are probably interested in having less regulations related to this too. So it wouldn't be surprising if this rule was withdrawn in some capacity. I don't know where it fits on the priority list, of course. Maybe there's a lot others, but it was a new rule under this administration, and therefore it's certainly, I would assume, to be on a list. So.
Thank you, Daniel. Andrew asks, and this is kind of open to the panel, has there been studies done on water quality on bodies of water that allow recreation versus a body of water that doesn't allow recreation? It's kind of a...
I can start again. Starting is fun because then others have to correct me. I love it. I don't know of any specific studies on water quality for waters include a designated use of recreation versus those that are not designated for recreation. But under the Clean Water Act, EPA does a lot of science. So in a sense, the 50 states and all the Indian tribes don't have to duplicate figuring out what concentration of contaminants are consistent with different designated uses. And their website for looking at criteria, which is what all this science is called. What are the criteria for different kinds of recreation? Swimming, what lawyers call body contact water sports. Lawyers have fun. Probably have a lower amount of different contaminants that are consistent with body contact water sports with swimming than sailing, for example, unless it's me who's really good at flipping sailboats. But if you're, I think looking at some of the criteria documents that EPA has on its website might get at sort of some of your underlying questions about recreation versus non-recreation water quality.
All right, we have.
I was just going to add to that. Okay. I can remember way back when our first draft water quality standards were sent to EPA Region 5 for review. And we actually had a couple of water bodies where we were not designating primary recreational contact, because these were not waters that anybody would be going swimming in. They're shallow, mucky bottomed, heavily stained, highly organic ponds, essentially. And we were essentially told, you need to make a determination or a demonstration that they could not achieve primary contact quality, and we opted not to. Point being is that it lies, as you mentioned, with that fundamental goal of the Clean Water Act to protect fishable, swimmable quality in the nation's waters. And so there's a whole lot of reasons why recreational uses may or may not be supported. They may be bacterial, they may be pesticides contamination, they may be harmful algal blooms and toxicity from that. I'm not aware of a particular or singular study that would necessarily answer all of this person's questions, but I'm sure there are some resources out there.
Thank you, Nancy. We have a question from Caleb. If a Superfund site has a possibility of contaminating groundwater that leads leads both into the city as well as the tribal nation, what can the tribal nation do in regards to using its reserved rights? So
That sounds like a situation where you need a good lawyer and you need to cite the Maui Supreme Court decision. If there is a release of contamination to groundwater that then makes its way into surface waters and exceeds human health or whatever water quality criteria, then that needs to be treated as a discharge and controlled through an NPDES permit. That's one way to go. It's not easy. It will take time, and like I said, it'll take a good lawyer and probably some data, but that's one legal decision that has really explicit bearing on that question.
All right. Evelyn asked, Donna, and I'm targeting you as our fill-in EPA representative, would desired fish consumption rates be considered?
Were I still at EPA, and I'm not, I wouldn't touch the idea of what's desired levels with a 20-foot pole. In that there is an emphasis in this rule of trying to set standards at the sort of non-suppressed levels of things like fish consumption. And I think EPA is expressly perhaps trying to get out of the business of deciding what's desired and not. But I'm just speculating myself, but there is language in there about the issues of suppressed uses.
Thank you, Donna. We have an anonymous question. Should states begin a conversation with state recognized tribes on reserved rights if the state has no federally recognized tribes? Maybe that's a question for Daniel, where the state recognizes the tribe's existence, but it's not federally recognized. Have you heard anything under that heading, Daniel?
No, I mean this rule applies only to federally recognized tribes. States, I mean California being one, has done a really nice job at incorporating and including the states that they recognize as California historic tribes in a lot of their processes, and treat them as governments through their state work. But this rule necessarily would not apply to the inclusion of those tribes through this EPA and state water quality standard setting process.
Okay, thank you, Daniel, for the clarification. Evelyn asks, is it possible to have changes considered outside of the review period for states, for the state? So I leave that open.
All right.
Donna,
Again,
thank
kicking
you,
it off.
Donna.
This is not specific to the tribal reserved rights, but the process by which states, and I see Jennifer Wagall of Oregon is here as well, develop water quality standards. And the Clean Water Act as a statute is really fond of public input, public comment, public notification. And there are requirements that as states develop water quality standards, that they make them available for the public for review and comment. Similarly, once a state has gotten those comments and then all it what consultation with tribes and all those other largely public processes, then submit them the result of those discussions to EPA. EPA also has to publish in the Federal Register when they receive water quality standards from a state or tribe, and once again subject to public comment. So is it possible to have changes considered outside of the review period of the state? I think the affection that Clean Water Act has for development of water quality standards and also for public input broadly would suggest to me that the answer is yes.
Thank you, Donna.
Well, let's see if Nancy agrees. I don't know, or if Jennifer. Anything to add?
All right.
I have to say I was busy typing a response to one of the questions in the chat. Sorry.
Okay.
All right.
I see Jennifer went live. Do you have anything to add about opportunities to have changes and concerns raised outside the quote unquote review period of the state?
Yeah, just nice to see everybody. I'm Jennifer Weigel from Oregon. And we'll be presenting next week. But in regard to this question in particular, I'm not going to opine on what I think the rule requires or doesn't require of states, but just more as a general matter. And each state kind of embarks on some of these processes a little bit differently. I know in Oregon, I'm going to spend a little time talking about this next week. One of the ways in which we do it is we have sort of a planning process where we kind of line up what our plans are over the next couple of years about different rules that we plan to embark upon, and have a priority setting and work planning process where we invite all sorts of public engagement. And I'll talk a little bit next week about how we engage with tribes in that process. And then there is also sort of the rulemaking process itself that we embark on kind of on a project specific basis. So there's a couple of spaces and times where for us as a state, trying to weave in that all together is going to be helpful for us to manage those processes. But I think for us, like also, we would really, if there is something that a tribe was interested in, anytime that came up or tribes wanted to have a conversation with us, then we would welcome that opportunity to have a conversation. So I guess to me, I would put things in two bins, which is when should we be having those conversations, and when might we be able to fit it into sort of our various sorts of work planning and administrative processes to actually be able to think about how we would plan that work.
All right, I think we're almost at our end of our presentation. I believe we're over at 1:30, or at least on the West Coast side. Is that correct? Or NCAI hosts? If we do, we just have time for one more.
Yes, yes, please go ahead, Ken.
Okay, we have Rachel, but a lot of the questions that I'm reviewing can be answered on the next session as an enticement to join on January 30th. So Rachel asks, how could different executive administration on opposing ends of the spectrum of respect for tribal sovereignty and tribal rights impact the enforcement of the TRR rule by EPA? I'm at to dig in my memory bank of the TRR rule. Oh, tribal reserve rights.
Yeah.
Who am I? It's been a long day, Donna.
Oh, but the day's winding on. No problem.
I don't know if we have an answer. I think it just is a good reminder that we need to continue to be vigilant and persistent and creative in finding ways and partners so that we can work together with willing partners to protect our water resources.
Yeah. Well, I think we're at our hour, and I would like to thank our panelists, and a special thank you to Donna for filling in for us. What a great job, Donna! Thank you so much, Daniel, Jennifer. Excellent, thank you. And I know that will be well received on January 30th, part 2. Please join us then. I'll turn it back to our NCAI host.
Thank you, everyone, for attending. Looking forward for next week, same time, 3 p.m. Eastern Time. If any questions are not answered during this webinar, we're going to let all the panelists know about these questions, so they will make sure they'll include those in their presentations or during the question and answer session. Looking forward to see you all next time. Thank you very much. Have a great day.